Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineer. Hindi entitled sa interest itong si akusado kasi nga ang intention of the parties ay to condone or to extinguish the debt. And take note na nung at that time na naipanalo ni abogado yung case ni akusado, magre-retroact yung effect nun at that time that there was a condonation or there was an agreement as regards the condonation of the debt of abogado to akusado. And therefore, at that time na kinondone yung debt na yun, supposedly yung principal hindi na yan nag-earn ng interest during the pendency of the happening of the suspensive condition. So take note of that. So this is a classic example of an obligation to do or not to do, and
with the retroactive effect as to the happening.
Retroactive effect is made applicable. Okay? So take note of that. Ulitin lang namin that the rule there is that there is no fixed rule. Hindi laging retroactivity ang magpe-prevail because the court has the discretion, no, to apply whatever is just and fair. Yes. Okay, so let's proceed with Article 1188. Attorney Uy, ano ba yan?
So, Article 1188, the creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition.
So, ang sinasabi naman nito, Attorney Uy, pending the fulfillment of the condition, may mga rights ang parties na pwede nilang gawin to preserve their rights. They have the rights to preserve their rights. Okay, so as to the rights of creditor, Attorney Uy, ano bang pwedeng gawin ni creditor?
Sabi dun sa first paragraph ng 1188, he may take or bring appropriate actions for the preservation of his right. Thus, he may go to court to prevent the alienation or concealment of the property of the debtor or to have his right annotated in the registry of property.
So, pwede yan. Para
So, hindi pa
maprotektahan.
nangyayari. For example, I will give you 10,000 I will give you a parcel of land. Provided you pass the bar exam. So, hindi ka pa nakakapasa ng bar exam. So, how will you protect or preserve your right as a creditor? So, ang sabi dyan, annotate the obligation in the certificate of title.
Sa registry of property to protect your right.
How about the rights of the debtor?
Well, in this case, the debtor is entitled to recover what he has paid by mistake prior to the happening of the suspensive condition. And itong karapatan na to is being granted to the debtor because the creditor may or may not be able to fulfill the condition imposed.
Kasi ang kaibahan naman sa debtor, right to recover what he has paid by mistake prior to the happening of the suspensive condition. For example, I will give you 10,000 pesos provided you pass the bar examination. And by mistake, akala ko nakapasa ka na, I gave you 10,000 pesos. Actually, hindi pa. The suspensive condition, wala pa, hindi pa na-fulfill.
And this is a case of
you may recover.
This is a case of solution indemnity, which is based on the principle that again, no one shall enrich himself at the expense of another. Okay, let's proceed with Article 1189. Yes. So if you're going to read Article 1189, meron yung requisites na dapat ma-comply para ma-apply natin ang 1189. We suggest that you go to your new civil code, you read Article 1189. It's kind of lengthy, but we are here to discuss the requisites on how you will apply that article. Ano ba yung requisites niya na to?
So first, the obligation is a real obligation. Again, real obligation is an obligation to give or to deliver. Pangalawa, the object is a specific or determinate thing. Third, the obligation is subject to a suspensive condition. Fourth, that suspensive condition has been fulfilled. Panglima, there is loss, destruction, deterioration of the thing during the pendency of the condition.
So, again, may pinag-usapan tayo dyan na
yes.
loss, no? Pagdating sa loss, deterioration, or improvement of the thing.
And again, dun sa requisites, importante, alam nyo kung ano yung real obligation, kasi discuss natin yan, alam nyo kung ano yung specific or determinating, at alam nyo din kung ano yung suspensive condition. Yan yung sinasabi namin na yung basic na magagamit natin in the latter part of the discussion.
So, kung hindi mo mag-grasp yung mga yan, balikan nyo yung previous lectures. Meron kami, they are already there as discussed. No? So, pag-usapan natin na yung iba't ibang uri naman ng cases of loss, deterioration, or improvement. Pagdating sa loss, effect. Effect of loss of thing without debtor's fault. Nawala.
Yung number 1, dun sa 1189.
So, there's loss of thing, but the loss is not on account of the debtor's fault.
Ibig sabihin, loss without the debtor's fault. Isipin mo muna, walang fault si debtor. So, ibig sabihin, fortuitous event. Ito. At ano nga ulit ang rule natin kapag may loss due to fortuitous event? Generally, the obligor debtor is not liable.
If it's specific.
Dahil nga without debtor's fault. Example.
Limbawa, si debtor obliged himself to give the creditor his car worth 100,000 pesos if the creditor sells the debtor's property. Now, the car was lost without the fault of the debtor. So, in this case, since the car was lost without the fault of the debtor, then the obligation shall be deemed extinguished and the debtor is not liable to the creditor C, even if C would be able to sell the property. Because as a general rule, a person is not liable for fortuitous events.
Yan ang una, madali yun. So
Madali
without debtor's fault or negligence, you can consider as fortuitous event, hindi liable. Ang pangalawa naman, loss of the thing through the debtor's fault. Ayan, meron ng fault or negligence dito si debtor. Kaya, it resulted to the loss of the thing.
Such that, for example, in the previous example that we've given you, if the loss of the car was due to the negligence of the debtor, then in that case, si creditor will be entitled to demand damages. So, for example, in this case, he would be entitled to demand 100,000 pesos plus incidental damages. Kasi kasalanan niya, he is at fault because he was negligent.
Laging may damages kapag laging may damages kapag may negligence or fault.
At walang fortuitous event dito. So,
Yes,
liable
dahil the loss was due to the debtor's fault. Dito, the obligation is also extinguished, pero it is converted into payment for damages.
Yes. So, that's as regards to loss. But what what if deterioration naman yung ano yung deterioration compared sa loss?
I think deteriorates when its value is reduced or impaired with or without the fault of the debtor.
Na-reduce yung value.
O kaya na-impair. Yung value, may deterioration.
So, for example, guys, yung kanina binigay nating example, yung kotse, yung sasakyan, nawala. Pero sa example naman natin ngayon, if the car figured in an accident, halimbawa, na bangga, or na aksidente, nasira yung kotse na meron tayo, walang loss doon. But there's only deterioration such as when the windshield was broken and some of its panes were scratched away. And that is without the fault of the debtor. So what would be the rule there?
So, it will reduce the value, kasi it will reduce the value of the car, and the creditor will have to suffer the deterioration or impairment in the amount of 20,000 pesos.
So in short, si debtor hindi siya liable to pay the reduced amount of, yung 20,000 pesos.
Ang rule dito, the creditor will suffer the loss.
Kasi hindi naman kasalanan nga ng debtor.
Yes, the deterioration pala rather. Suffer the deterioration.
So, what if naman the deterioration is through the debtor's fault?
Yes, ito naman, deterioration through the fault of the debtor.
Halimbawa, kaya nabasag yung windshield, na-scratch yung paint, dahil kasalanan naman ni debtor. So, in this case, the creditor may choose between first rescission or cancellation of the obligation with damages, or fulfillment of the obligation also with damages. Kapag ang pinili niya ni creditor is rescission or cancellation of the obligation with damages, then si debtor is liable to pay 100,000 pesos,
yung value ng car,
which is the value of the car before its deterioration, plus incidental damages if there is any. Kung ang pinipili naman niya ay fulfillment of the obligation with damages, then si debtor is bound
to deliver the car
to C and to pay 20,000 pesos corresponding to the deterioration of the car.
Pay 20,000 plus incidental damages. So it is wise to choose yung fulfillment of the obligation with damages. O kasi may car ka na, may 20,000 ka, tapos may incidental damages. So tapos na tayo sa loss. Tandaan niyo yung loss, ano ang rule kapag with debtor's fault, ano ang rule without debtor's fault. Pangalawa, deterioration, ano ang rule with debtor's fault, ano ang rule without debtor's fault. O pangatlo naman, improvement
of the thing by nature or by time. So a thing is improved when its value is increased or enhanced by nature or by time, or at the expense of the debtor or creditor. So suppose the market value of the car na sinasabi natin kanina nag-increase. For some reason, who gets the benefit?
The improvement shall inure to the benefit of the creditor. Because ang rationale dyan, kasi sabi natin kanina, doon sa deterioration, ang magsasuffer din si creditor
kapag walang fault si debtor.
If there's no fault on the part of the debtor. So dito naman, yung improvement of a thing, by nature or by time, kung may improvement, it will accrue to the benefit, or it will inure to the benefit of the creditor.
It's fair enough.
It's fair.
Yes. Now, what if the improvement of that thing is brought about by the debtor, or siya yung gumastos at the expense of the debtor? Then in this case, what if during the pendency of the condition, si debtor had the car na pinag-usapan natin painted, pinaganda niya,
gumastos dito ngayon si debtor.
ginastosan niya para yung seat cover mapaganda. So ang tanong dito, sino ngayon ang magbe-benefit dun sa improvement na yun?
So under Article 1189, yung number 6, they will have the right granted to a usufructuary with respect to improvements made on the thing held in usufruct.
Ano ba yung
usufructuary? It's a contract.
Usufructuary. So he has the beneficial use of the car. I mean, habang ginagamit nyo, dito may benefit siya. Maganda yung pintan.
And the right to preserve.
So, maganda yung upuan niya. So,
Enjoyment.
usufructuary. May enjoy niya yun. Okay? Pero, yun nga, that's the benefit that he would get from it.
And also take note na yung 1 to 6 na diniscuss natin, it is the effects in case of loss, deterioration, or improvement pending the happening of the suspensive condition. Yan yun. Kasi may mga mangyayaring loss, deterioration, or improvement before the fulfillment of the suspensive condition.
So take note of the rules under 1189. Now under 1190, this is something to do with the effects of fulfillment of resolutory condition. So resolutory condition naman tayo. So ano bang effect ng fulfillment of resolutory condition?
Okay,
and
ulitin
obligation to
natin.
give?
Pag obligation to give, the obligation is extinguished and the parties are obliged to return to each other what they have received under the obligation. So may duty to restore or to return. The obligation is extinguished, tapos may duty to return what the other has received. Example.
Example. Limbawa, si debtor, inoblige niya yung sarili niya to allow the creditor C to use his car until the debtor returns from, let's say, the province. So habang umuwi sa probinsya si debtor, hinayaan niya munang gamitin ni creditor yung car na meron siya pinahiram niya. Upon the return of the debtor from the province, then the creditor must give back the car.
Once the resolutory condition has been fulfilled, isoli mo. Nanghiram ako ng book kay Attorney Maralit. Sabi, ang condition, ibabalik ko kapag natapos ako sa aking Oblicon na klase. So, kapag natapos na yung aking Oblicon na klase, the obligation is extinguished. And I am bound to return.
Kasi nga, the effect of the happening of the condition is to annul the obligation as if it had never been constituted at all. And in this case, the parties actually intend to return the car na pinag-uusapan natin dun sa example. How about in obligations to do or not to do, attorney?
So the courts shall determine the retroactive effect of the fulfillment of the resolutory condition as in the case where the condition is suspensive. So the court is given discretion to apply the retroactivity.
So take note of Article 11, 90 of the new Civil Code. Now, under Article 1191, dito naman yung kinds of obligations according to the person obliged. Ba't ibang uri ng obligasyon ng naaayon sa kung sino yung obligor. No?
So we have two kinds.
Two kinds?
Yung unilateral and bilateral. So yung una, unilateral, from the word itself, uni. When only one party is obliged to comply with the prestation. This is usually found in contracts of loan o kaya donation. Yon.
So in a contract of loan, the lender, yung nagpapautang, yung creditor, has the obligation to give. No?
Yes.
After the lender has complied with his obligation, then the debtor has the obligation to pay. So it's unilateral.
Unilateral kasi isang parties lang ang bound to comply
At
with
a
the
time.
prestation. Yes.
So sa donation, ganun din. Si
Oo,
donor,
si
di ba?
Si donor, ang meron siyang obligation to
Give.
deliver the property donated.
Now, how about bilateral? Ang bilateral, meron tayong tinatawag na reciprocal bilateral obligations and reciprocal bilateral non-reciprocal obligations. So, ang bilateral, this is when both parties are mutually bound to each other. In other words, both parties are debtors and creditors of each other. So,
yan, ang karaniwan yan dun sa contract of sale. The seller is bound to deliver the thing to the buyer. And in turn, the buyer is bound to pay the purchase price to the seller. So, pareha silang debtor and creditor of each other.
And that means that is a reciprocal bilateral obligation.
Yes,
Kasi sa contract
reciprocal
of sale.
bilateral.
Kasi yung isa namang bilateral, which is non-reciprocal obligations, are those which do not impose simultaneous and correlative performance on both parties. In other words, the performance of one party is not dependent upon the simultaneous performance of the other. Ang example niyan, is halimbawa, si debtor, nanghiram siya kay creditor ng 50,000 pesos. Si creditor, on the other hand, hiniram naman niya yung kotse ni debtor. So, the performance by the debtor here of his obligation to C is actually not conditioned upon the performance by C of his obligation and vice versa. Kasi magkaibang obligation na meron sila. Okay? To take note, kasi kanina dun sa reciprocal bilateral obligations,
Isa lang ang contract of sale,
yes,
pero both parties are mutually bound to comply with what is incumbent upon him. Dito naman sa non-reciprocal, dalawa ang contracts. Yung isa kanina, yung example is a contract of comodatum. At yung isa naman is a contract of loan. So yan, nakalagay dun is contract of loan, contract of donation.
So take note of that, guys, yung difference ng non-reciprocal bilateral obligation and reciprocal bilateral obligations na meron tayo. Now, in this case, what would be the remedies by the injured party in case there will be a breach of obligation?
Yes, so in case one of the obligors does not comply with what is incumbent upon him, the injured party may choose between the two remedies. First is an action for a specific performance with damages. Pangalawa is action for rescission of the obligation, also with damages.
So, to give light on this, let's give an example. Halimbawa, in a contract of sale. So, bentahan ito, no? Si seller, he bound himself to deliver the car.
Yes.
And the necessary document duly signed by him to the buyer, let's say, on December 1. And the buyer would deliver the payment on the same date. So, bilateral ito, reciprocal contract of sale. what if si S would not comply with his
obligation to deliver the car.
Hindi deliver, wala yung
So,
documents. Ano mangyayari?
the buyer may, in an action for specific performance, demand the delivery of the car with damages. Or B, or the buyer may demand from the court the rescission of the contract also with damages.
When a party demands rescission in a reciprocal obligations, he in effect treats the non-fulfillment by the other party of his obligation as a resolutory condition.
And again, that those remedies are alternative in character.
Pili ka lang. Okay. May nabanggit kasi ditong rescission, sorry. May nabanggit ditong rescission. Ano ba yung rescission na yan?
So the effect of rescission is mutual restitution.
Right, Attorney Uy, so we have come to discuss the last article under Section 1, no?
Pure and conditional obligation.
So medyo mahaba ang pure and conditional obligations, but we are now under Article 1192, and Article 1192 provides...
Yes, Article 1192, in case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear its own damages.
So, here, Article 1192, dinadiscuss nito yung possible na magkaroon ng breach of obligation ng
Yes.
either of the
Both
parties or
parties.
both parties actually. So, where both parties are guilty of breach, ito yung rule. First, kapag,
the first infractor is known, o kung sino yung una nag-violate, alam ko sino yung nag-violate. One party violated his obligation. Subsequently, the other also violated his part of the obligation. In this case, the liability of the first infractor should be equitably reduced.
alright, malinaw na alam natin na liable yung first infractor kasi
yes.
kita naman. Kaso, i-reduce mo yan kasi subsequently, nagkaroon din mo ng violation ng other party.
Yes.
So, it's just fair na i-temper ng courts. And courts magti-temper nun.
Yes,
Kung
to
ibig sabihin ng
reduce or
temper,
mit-
i-reduce
or to mitigate.
or mitigate yung liability ng first infractor. However,
Yes.
Attorney Uy, there are instances wherein there has been breaches in the obligations and it is not known who really is the first infractor. So what would be the rule in that case, Attorney Uy?
Yes, so if the first infractor cannot be determined, the rule is that the contract shall be deemed extinguished and each shall bear his own damages. Ay di kanya-kanya na, no?
Kanya-kanya na tayo. Hindi mo malaman kung
sinong nauna.
nauna So,
Unang nagloko, hindi mo alam.
para iba na yan. This means that the contract or the agreement shall not be enforced.
Yes.
And in effect, the court shall not provide remedy to either of the parties who must suffer the damages allegedly sustained by them. So, the court would leave them as they are and they would have no
remedy
available.
against each other.
So that wraps up our discussion as regards Section 1 in the different kinds of obligations, particularly pure and conditional obligations from Article 1179 to
1192
of the new Civil Code. And in the succeeding video lecture, we will be discussing Section 2 as regards obligations
which
with the
pertains
period.
to obligations with the period, Section 3, alternative and facultative obligation, Section 4, we have joint and solidary obligation, Section 5, we have divisible and indivisible obligations, and
Section 6, obligation with a penal clause. Alright, so on that note, guys, we hope you've learned from Section 1, pure and conditional obligations, and we're looking forward to see you in the next video lectures that we have. This has been Attorney Benji Marali.
and Attorney April and
Laging tatandaan, ignorance of the law
excuses no one.
See ya!
Annyeong!